Good afternoon, everybody, and thank you for joining us today for the CondoWise Learning Series. We're at session number 10, and today we're going to be talking about insurance and standard unit bylaws. Please use your Q&A function to submit your questions, and I'm really happy to have with us a diverse panel of our own team with us. I just want to remind you before we jump into it that since every condo is unique, the advice provided in our sessions is of a general nature and is not legal advice. We recommend that you consult with the condominium corporation's lawyer to ensure that the solution that is chosen is correct for the condo. So if we could advance the slide. Our speakers today are Ashley Winberg, Julia White, and Shannon Penny. And we're going to talk about the pandemic first. So Shannon, I'm going to turn it over to you. So if you could just give us a brief update, we'd appreciate that. Thank you.
Yeah, perfect. Thank you very much, Patricia. So good afternoon, everyone. So as I'm sure you're all aware, on June 11th, Ontario entered into step one of the three-step plan to reopen the province. The plan to reopen moves away from the original color-coded regional framework and is now more sector-focused and applies across all of Ontario. We will remain in each step for at least 21 days to monitor the impacts and case numbers as more restrictions are eased. And it will also depend on Ontario's vaccination percentage rate, which as today, 75.16% of adults aged 18 and older have received their first dose, and 19.52% of adults aged 18 and older have now received their second dose as well. So Ontario will enter step two around July 2nd, which is 21 days after we entered into step one. Also, 70% of adults will need to be vaccinated with one dose and 20% need to be vaccinated with 2 doses. And from the statistics I just provided, we are virtually there. So step two will also allow for indoor gatherings of up to 5 people, along with outdoor gatherings of up to 25 people. Outdoor sports and leagues can also resume, along with personal care services. Indoor religious services can also resume with a limited capacity of 15%, and retail restrictions will be further eased, allowing essential retailers to operate at 50% capacity and non-essential retailers at 25% capacity. Outdoor amusement and water parks can also reopen, as well as outdoor live music, events, and attractions. So the final step will see life return mostly back to normal and can begin 21 days after we enter step two, and when 70 to 80% of adults in Ontario have received at least one dose of the vaccine and 25% have received both doses. So larger indoor and outdoor gatherings will be allowed, although the province have not yet specified any specific numbers. This step also includes a return to indoor sports, recreational fitness, and indoor dining and casinos. We do understand that condominiums are eager to open its amenities. Currently, only outdoor recreational amenities are permitted to open, so such as tennis courts, basketball courts, football fields, and also outdoor swimming pools and playgrounds. So the condos should adequately manage the risks and aim to reduce or eliminate the transmission of the virus. And should the outdoor amenities open, the condo must ensure that any person who enters or uses the amenity maintain a physical distance of at least 2 meters from any other person using the amenity. So indoor fitness facilities and indoor swimming pools, unfortunately, will not be permitted to open until the final step of the reopening plan, which is estimated to be around the end of July. So across the province, more people will be able to book their second dose of the vaccine. Those who received the first dose of the AstraZeneca vaccine can now book their second dose after 8 weeks instead of waiting 12 weeks. And those who live in regions where the Delta variant is spreading and receive their first dose on or before May 9th can also make an appointment for their second dose. So certain regions do have pop-up clinics for postal codes in the hotspots, and no appointment is necessary. But I do recommend that you check the line. You can check that on Twitter prior to attending, as I know some days the line has been in excess of around 4 hours. Please remember that each region does have different eligibility, so it's important to keep up to date with the information that's released by public health in your area. So thank you very much. I will pass you back over to Patricia.
Thanks very much, Shannon. That was a really comprehensive update. It sounds like we're making some progress here, which is really good. And it should be a better summer than even last summer.
Yes.
So with that said, we're going to talk about an exciting topic today, insurance and standard unit bylaws. And we're going to start really with a poll today, just to get a sense of those of you in the audience, what you're experiencing. So our first poll question is, and maybe we could put that poll up on the screen. Has your condominium's premiums increased materially year over year for the last 3 years or more? We've been hearing about increases, and we've been hearing about some pretty dramatic increases. To me, material is more than 5%. So I'd be obliged if you would answer the poll and let us know where you're seeing, if we're seeing these real increases. I know clients in our book are seeing them, but it's good to know if it's across the province. Okay, so 81% are indicating that they are seeing increases materially year over year. So that's important. Our second poll is, has your condominium had a high level, more than 3 claims in the last 3 years? The reason this is important question is to see where the correlation is between claims history and these increases that we're seeing. Interesting. So now we're seeing an inversion in our responses. 86% have not experienced more than 3 claims, a high level of claims. So our final question is, has your condominium's deductible increased more than 25% in the last year? This one I'm just curious about. I want to see if there has been growth in that deductible component. Often when we're set as directors, we actually contemplate if the deductible should go higher so that we give ourselves some more flexibility and keep the premium low. So let's see if we've seen some increases. Ah, somewhere in the middle there. Look at that. Interesting. So we're almost evenly split, that we have seen increases of more than 25%, and many are not seeing that. So it's interesting to see where this is translating to as we take you through this discussion today. I'm pleased to have Ashley Winberg with us. And Ashley, I'm going to turn it over to you. And if we could advance to the next slide, that would be great. Thank you.
Hi, everyone. Thanks for joining us today. So the insurance market for condos is currently a hard market. A number of condominiums have seen soaring premiums and deductibles. In some jurisdictions, particularly BC and Alberta, premiums have been reported to increase by over 700%. Insurance is all about risk and economic conditions and heightened risks. In terms of condos, the heightened risk factors are increased severe weather, higher property values, higher unit vacancy rates, and increased water damage claims by owner-driven conduct. For instance, there has been some instances where there's been catastrophic loss simply because someone has left their bathroom, their bathtub running, and in turn has caused water to damage, units and various floors below them. So condo insurance is a risky area to insure, even at existing pricing levels. And in and around 2018, the condo market started to shift from a soft market to a hard market. And because of that, contributing towards that, many companies chose to exit the condo market altogether because they were of the opinion that regardless of the premium that they charged, there are conditions inherent in this market that will prevent them from making some quote unquote real money. And then those insurers who have remained in the market have had to raise their premiums and deductibles significantly, reduce their capacity. So they've reduced how many condos they're willing to insure, and are being much more selective by only insuring specific condos and shying away from condos that have unattractive features, such as if it's an aging building or a condo with known water plumbing issues, or if a condo has no standard unit bylaw or reasons due to the condo's geographical location. So because of the hard insurance market today, ensuring that your condo has a standard unit bylaw is more important now than ever. And our discussion today is going to illustrate the importance of standard unit bylaws, some misconceptions surrounding standard unit bylaws, and action that can be taken by corporations to make their corporations more attractive to potential insurers, and also trying to maintain their existing premiums at the rates they currently are. If you could please turn to the next slide. Thank you. So as the majority of you are all aware, under Section 99 of the Condominium Act, the corporation has to maintain insurance for damage to the unit and the common elements caused by major perils. One of the most frequent major peril is water. There's also, fire. However, corporations are not required to maintain insurance for any damage to improvements made to the unit. Next slide, please. Now, what constitutes improvement? For this section of the Act, pursuant to subsection 99(5), what constitutes an improvement is determined by reference to either the standard unit definition contained in a standard unit bylaw, if one has been enacted by a corporation, or the standard unit definition set out in a schedule that would have been provided to the corporation 30 days after turnover if the corporation was created after May 5th, 2001, and if that corporation does not already have a standard unit bylaw. Next slide, please. So the standard unit definition does not change the boundaries of the unit. It is merely a theoretical concept that is used to assist corporations with establishing the extent of their obligation to insure their units under Section 99 of the Act. The standard unit definition defines what parts of the units are standard and which parts of the units are improvements. So the parts of the units that are standard would form part of the standard unit, and anything else that's not included as forming part of the standard would be deemed to be an improvement. And as such, the corporation would not be required to insure them under Section 99 of the Act. So a standard unit can be defined in either a bylaw or in a schedule. Currently in the Act, there's nothing that stipulates what items must be listed or included in the definition of a standard unit. And when it comes to the schedules provided by declarants, essentially this type of schedule would be provided by the declarant 30 days after their turnover meeting. And it would set out for each class of unit what the responsibilities for repair and maintenance are. However, aside from Section 45 of the Act, there is nothing in the Act or the regulations that specify the form or content of the schedule referred to in Section 43 or Section 45. In my experience, very few condos actually have these schedules, and even if they were once provided to them, they may no longer have them in their possession because they're relatively easy to lose after a number of years since they're not registered on title. Next slide, please. Thank you. So the question that remains is, what constitutes an improvement if a corporation does not have a standard unit bylaw or a schedule provided by a declarant? And there are two cases that discuss this matter. One is D'Alessandro versus Carlton Condominium Corporation number 43, and the other is Cci versus Metropolitan Toronto condominium corporation number 683. D'Alessandro was a Superior Court of Justice decision, and Cci was a Toronto Small Claims Court decision. So they're not like Ontario Court of Appeal court decisions or anything, but they're really the only cases that we have on this issue. So I'll briefly discuss D'Alessandro first, because it was the first case, and that decision was rendered in 2006. So in that particular case, the unit owner had installed hardwood flooring in her unit, and her hardwood flooring was damaged by a water leak. And the issue before the court was whether the corporation had to repair the damaged hardwood flooring by replacing same with carpet, which was what was originally in the unit when it was constructed, or if the corporation had to repair the unit by reinstalling new hardwood flooring. So this corporation was created long before 2001, so it didn't have a schedule from the declarant, and it did not have a standard unit bylaw. So the corporation argued that there was a hypothetical standard unit, which consisted of the finishes that existed when the declaration was registered. And because the unit owner had installed the hardwood flooring herself post-registration, the hardwood flooring in her unit was an improvement for which the corporation was not responsible to repair. However, in spite of clear evidence that the hardwood flooring was an upgrade installed by the owner post-registration, the court rejected the corporation's argument and held that in absence of a standard unit bylaw or schedule provided by a declarant that defines a standard unit, the corporation was responsible to repair the damaged hardwood flooring. So the court essentially said, if a condominium doesn't have a standard unit bylaw or doesn't have a standard unit definition, really vis-a-vis a standard unit bylaw, there can be no unit improvements, since unit improvements are determined by reference only to the standard unit definition. And that can only be defined by bylaw or in a schedule provided by a declarant. So if there's no standard unit definition, everything in the unit except for the owner's chattels are considered as forming part of the standard unit based upon this court's interpretation. I personally disagree with the decision of D'Alessandro as it stands for a proposition that, absent a standard unit bylaw or schedule, everything in the unit, including very clear, obvious upgrades, form part of the standard unit, which in practice just isn't fair, because then everyone else is paying for replacing someone's, incredibly unique hardwood flooring or something imported when, and that's just not fair to everyone else. It doesn't make sense in the long run. So thankfully, the Cci decision came around in 2011. And again, this is a decision of the Toronto Small Claims Court. In Cci, a pipe in a unit owner's dishwasher burst, causing water damage to her hardwood floor. And she replaced the hardwood floor. The hardwood floor was really covering up the original broad loom flooring. So the unit owner made a claim under her insurance, her own personal insurance, for the cost of replacing the floor. And the unit owner's insurer repaired the damage and then sought to recover costs from the corporation. And so the Toronto Small Claims Court dismissed the insurer's claim for the following reasons. In the declaration of the condo, there was a statement that provided that any unit owner's insurance must contain a waiver of subrogation against the corporation. So the court held that because of this requirement, this prevented the unit owner's insurer from asserting a subrogated claim based on an alleged right of the unit owner against the corporation. The court also stated that in the maintenance and repair section of the corporation's declaration, the unit owner had a duty to repair her unit, including any improvements to her unit. And my favorite takeaway from this decision is that the court noted that when there's a question of whether an item is an improvement, it should be determined in relation to a broader number of factors rather than applying a strict interpretation of the reading of the meaning of, rather than applying a strict interpretation of improvement as set out under the Act. That is, the determination of whether something is an improvement should be considered using a broad number of factors, including whether the corporation has a standard unit bylaw or schedule provided by a declarant. So in this particular case, the corporation did not have a standard unit bylaw and it did not have a schedule provided by the declarant. Yet the court held that the owner's installation of the hardwood flooring was an improvement, even though there was no standard unit bylaw in place. So just some commentary on these two cases. One important takeaway from the study case is that the court found that it will confirm that it will enforce a waiver of subrogation contained in a declaration to bar an insurer from pursuing a subrogated claim against a corporation on behalf of the unit owner. So it's important that corporations make sure that in their declaration where it discusses insurance that should or must be obtained by owners, that it clearly states that if insurance is obtained by owners, same must contain a waiver of subrogation against the corporation. And in my personal opinion, the most important takeaway from this decision is that the court in Cci disagreed with the earlier decision about D'Alessandro. So this is good news in my opinion, because I disagreed with the court in D'Alessandro. However, although the court in Cci disagreed with the D'Alessandro decision, it doesn't really change the advice that we, or at least I, give my clients. I always advise my clients to err on the side of caution and to create a standard unit bylaw. So I think Cci just sort of reinforces that caution, because if a court in Cci could disagree with the D'Alessandro decision, who knows how another court might decide. They could either agree with the Cci or D'Alessandro or disagree with both, who knows? So there's really only one way a corporation can have certainty with respect to whether or not an item will be considered as forming part of a standard unit, and that is by creating a standard unit bylaw. So some key takeaways from these decisions. Number one, err on the side of caution. If your corporation does not have a standard unit bylaw that defines the standard unit, I think you should act on the assumption that everything in the unit, including obvious upgrades, form part of the standard unit and are the corporation's obligation to repair after damage and insure should an issue arise. Now, even if you have one of the schedules provided by a declarant, these can easily get lost since they're not registered on title. So I would still recommend that you create a standard unit bylaw. If you don't have a standard unit bylaw and you don't have a schedule provided by a declarant, still create a standard unit bylaw. And even if you have an existing standard unit bylaw, I would recommend that you reevaluate it because there's nothing in the Act or the regulations that stipulate what needs to be included in the definition of a standard unit. Sometimes corporations create their standard unit bylaw based upon the feature sheet that owners were given when they purchased their units directly from the developer. You don't need to define a standard unit based upon those features. And there's also a misconception that the standard unit has to be defined so that items that make the unit livable be included. And that's also not required. So it might be in corporations' best interest, given this current hard market, for corporations to reevaluate their standard unit bylaws if they already have one, or if they're considering creating one, and creating a very bare bones standard unit definition, because that might make the corporation more attractive to selective insurers in this market. And by creating a bare bone standard unit bylaw, you would be removing things like flooring, for instance. That would be considered an upgrade, and that is something that is frequently damaged by water escape and is always an issue of contention. So I would recommend either drafting a standard unit bylaw if you don't have one already, or if you have one already, reevaluating it and try and bring that definition of the standard unit to the bare bone as much as possible. And now I'll turn it over to Patricia. Next slide,
Well,
please.
thanks, Ashley. And I think that bare bones has a very broad concept, and we have to always be thoughtful when we go down the path of bare bones, because I think, and it's a good thing Richard's not here, because he would argue against this vehemently, because Richard's of the view, and I would agree, I think you have to get the unit to a standard where it's saleable, right? Because here's the thing, corporation doesn't want to use its funds just in case the unit owner walks away to fix up the unit. Mortgagees' interests should also be reasonably protected. So it can be valuable. And, Ashley mentioned taking out the flooring. I'm pretty sure these days I've seen most of the standard unit bylaws remove flooring. Nobody is covering flooring when they get the opportunity to visit the standard unit bylaw definitions. But, finding that really harmonious balance, depending on the type of condo as well. It can be effective to reduce the costs and the premiums depending on the type of condo you have, and only if it translates back, though, to a balanced approach with unit owner insurance, because I think this is the other piece. Unit owners should be made aware of insurance obligations for their own unit based on betterments and improvement definitions. This is why the standard unit is so valuable. It creates that delineating line so that unit owners can effectively obtain good unit owner insurance that's comprehensive. Comprehensive for a few things, making sure that they can have deductible insurance coverage. That's one of the features of many products these days. And that is so helpful, especially because we did see people have indicated that deductibles have gone up, right? And what we see in our client book is we may have units that are worth $750,000 in downtown Toronto, but for some of them, the deductible has gone up to $250,000. So the question is a matter of practicalness. Do unit owners have $250,000 lying around when they're paying their mortgage on, the $750,000 unit? And some may have the ability to deal with that deductible, but others may not. And the objective is to keep people living in their homes as well. So what I'm going to talk about is also the pending amendments to the Act. We went through a really big shift in the statute in November of 2017. Part of what was promised to us is a change and a repealing of Section 99 sub 5 and sub 6. Sub 5 deals with what constitutes an improvement and how it's determined by reference to a standard unit. And 99.6 deals with defining a standard unit. Now, these sections, I don't know when they're going to be repealed, And what I understand is going to happen is that we're actually going to get regulations that create a base standard unit definition where we have not passed a bylaw that actually puts one in place. So that's on the horizon, but I get the sense that perhaps the government has waited on this, especially because of the economic cycle that we're going through, and whether or not that's going to change the dynamics dramatically. I think it actually might help, because those condos that don't have the standard unit in place and find resistance in their communities to passing it are actually hurting themselves from an economic perspective. And I think we really need to think about that strongly in terms of how we manage risk. And I'm going to talk about that a little bit later on. Another pending change is to 105. 105 eventually is going to be replaced. And, currently right now, it says, that subject to subsection 4 and as well as subsection 3, you can charge back a unit owner that has caused damage to a unit, the common elements or the assets, if and charge that deductible back as a common expense. Okay, but it says that you also have the ability to modify that obligation by basically saying that if the corporation did not, by act or omission, cause the damage to the property, that the unit owner can be held responsible, and you can pass a bylaw to affect that language. Now, the new changes, though, are going to cause litigation Why? Because the new proposed section, sub 3, is that it says specifically that subject to subsection 4, that the ability to charge back the deductible to the unit owner does not apply if damage to a unit, the common elements or assets, if any, of the corporation was caused by an act or omission of the corporation or its directors, officers, agents, or employees. So what's going to happen now when this changes is that unit owners are going to say, it wasn't me. It was actually the corp. The corp was negligent. And then we're going to argue about who was negligent. Was it the unit owner or was it the corp? And that kind of debate is going to cost money, I think, in terms of legal time. And it could be avoided because you do then have the ability to alter your declaration if you want to shift the onus and basically say, it's otherwise going to be the unit owner in all cases, unless it can be proven clearly that it was the corporation. The amendment to the declaration, though, we all know requires consent, and it's a high level of consent. But these days, we're seeing the need to amend declarations in anticipation of changes of legislation, but also because of highlights that have come through in case law. For example, Lenny, people are focusing now again on amending their decks to make sure that that indemnity clause is broad enough to deal with compliance as well as damage to property issues. And Lenny, I think, has been talked about quite a bit, but you should be thoughtful about when you're helping your condos move forward and you're thinking about legislation changes. This is one of those deck amendments that might be very valuable for them to consider in advance, because the bylaw won't stand up to these changes in the legislation, as far as I'm aware, unless there are going to be further grandfathering provisions to allow those bylaws to stand. So if I could have the next slide, please. Thank you. What I wanted to share with you as well, and some of you may have heard about this in the industry, is that the Insurance Bureau of Canada in May of 2021 did release a very good report that analyzed this market that we're going through. And it analyzed it from a very interesting set of perspectives. What are the drivers for the hard market? And some of the interesting drivers were, some of the challenges of, limits on insurance, Ashley talked about, but also things like insurance rates being low. I thought that was a very interesting factor. We're going to put this link to the report in our chat box so you can actually read the report yourself. But I think when you're going now through best practices and reading these reports that show that people in the market are concerned, all right? And this was a national report. CCI, a member of our national executive, John Jeffs, did sit on the committee and actually brought to the table condominium concerns, which was wonderful to have a voice for condos in this context. But when we're looking at best practices, I think we really need to think about reputational, legal, and financial risk. Where are we going with these costs? Myself as a director and a condo owner, I think I want to make sure that we can actually carry these costs. So what I suggest to our book of clients is ways to cap or eliminate risk. First, I'm going to tell you, CCI is working on something very exciting through our Government Relations Committee. A subcommittee on insurance has been struck, and we're working on thinking through that for condos. So stay tuned and listen for more news on that. But in the interim, I really think that we know some of the key things. The question is, are we doing them? The first is passing a standard unit bylaw. I think that's very valuable, as Ashley has talked about, even just in defining the roles of and the obligations of parties so they get really good insurance as a unit owner. Encouraging our unit owners to get insurance is also important. You see some decks tell us that it's mandatory, but the question is, how do you enforce it? I suggest that at your AGMs, your town halls, just remind people, make sure you have your unit owner insurance. Amend your declaration, have the right types of indemnities in place, cap liability where you can, and shift the obligation of the insurance deductible to the unit owner, where you can actually establish, or put in place a set of parameters, which is that if it's not us clearly as the corp, it's going to be deemed to be the unit owner, because right now that debate still will exist. I would also suggest that, maintenance and repair. Sometimes it's easy to put off maintenance and repair because the common expenses are lower, but adequate maintenance and repair keeps our condominiums in good shape. It means that our systems will be in good condition relative to their age because they've been maintained, repaired. For example, pinhole leaks in our water supplies. We need to think about those practically, and whether there are good patches, whether there are reliable patches, replacements, or complete replacements of the system are things that can reduce the number of claims we have and insurable losses. Undertaking good corporate governance practices so that the board has a really strong routine around certain issues so that it doesn't attract liabilities to its directors. So there are no D&O claims, that it doesn't attract, issues under human rights defense costs. So you have to think about where the risks arise in your operations and have good practices around that. If you have a human rights policy, information management policy, and you stick to them, the corporation actually has good evidence to show that it operates at a fair level in accordance with the law and that it took all reasonable steps, which is good at mitigating damages. Get professional opinions. I know it's self-serving, but at the same time, practically, as a lawyer that sits on a condo board, I always insist on corporate opinions. Why? Because our professionals can take the risk. They're the ones who are trained. And then under Section 37, our directors are elevated from any personal liability because they have an opinion in front of them. And if they follow the opinion, they're exempt, right, from liability. Clear, concise records. Many of you in the property management industry that know, that are on the call with us today, know that having those records in place so that you can prove the conditions that the condo was in during a snowstorm, a rainstorm, a hailstorm is going to be important for dealing with those personal injury claims, slip and falls. And you want to make them as efficient as possible. Why? Because if litigation comes under our policy and drags out, if our cost to replace a damage in the unit is high, premiums will go up. Spending the reserve fund. I know some boards think that that's just an account for a rainy day. It is not an account for a rainy day. It's an account to avoid the damage that happens on a rainy day when your roof has not been replaced. So replace the roof, use the money, and stay on the timeline because it will increase the caliber of the condo, physical assets. Self-insure. There is a logical point, and I think boards need to be thinking about this more, about having an amount in their operating that deals with self-insurance. If the claim is $12,000 and if the deductible is $12,000, my experience is it's not worth the ramifications on the premium to make the claim. Save the money in a way that you can use it and apply it to claims if you can't be charged back to the unit owner. And like I had said before, unit owner coverage. Before I move on to a brief case law update, I wanted to tell you about in the report, there are a couple of things that you can identify which may help your clients. There is a number, a helpline that IBC has put together, page 35 of the report. Those condos that are finding it hard to get coverage actually can seek out help through IBC. And I think Caroline is also going to put that contact information in the chat, but it's also available on the National CCI website. Under the Resource Center, you can actually look up Insurance Bureau of Canada, and you can get the helpline number. They've actually helped a few condos in Alberta and in Northern Ontario obtain insurance when they weren't able to get the same in the market. As well, you wonder, do these steps or do these kind of initiatives, thinking ahead, make a difference? In the IBC report, there are a couple of case studies, and what they found is that when they rethought their risk in some of these case studies, they were actually able to obtain coverage and reasonable coverage. There was one that I thought was really interesting. A strata corporation in British Columbia saw its insurance renewal lowered from $130,000 in 2020 to $67,000 in 2021 after IBC's risk manager worked directly with the Strata Corp on an insurance procurement strategy and improved its submissions. So when it uses language like that, improved its submissions, it's actually looking at risk management tools. As well, legislatively, there have been changes across the country. In British Columbia, there has been a statutory change to move away from best pricing practices. And it really is sort of a misleading term. Best pricing practices there really was, the lowest common denominator in terms of multiple insurers coming to the table and insuring certain percentages of the risk or the loss, proposed losses or insurance liability for a condo. If it was, 10 cents for, 50% of the risk, and that was the cost, and then it was 85% for another insurer for 10% of the risk, the 85 cents was considered the best price. And now the government has said, no, we're not going to allow that structure. You're going to price it based on the different levels of coverage cost per the actual insurer. It's something really to look at, because when you change that percentage, obviously the proportions change and the price per insurance book changes for each of the insurers. So we will be seeing that hopefully evolve, and in Ontario, we'll see what happens. So now, thanks very much, Ashley. That was very insightful. I'm going to move to Julia. Julia is going to do a brief case law update on some new cases. Thanks, Julia.
Thanks, Patricia. So I'm going to go through two cases today. One is about a unit owner's oppressive behavior, and the second is about arbitrating a cost-sharing agreement between two condominiums. So the first case, Caroline, if you can switch to, perfect, is MTCC 580 versus Mills. So Mills lived in a small condo in downtown Toronto and had severe and pervasive disabilities affecting his ability to participate in the condo community, which required accommodation from the condo. The condo ended up bringing an application against Mills, who had for a number of years been terrorizing and harassing the community to the extent that other residents were refusing to use certain common areas, and third-party contractors couldn't enter Mills's unit to perform necessary maintenance. Mills made numerous complaints about his safety due to an alleged risk of asbestos in the unit, and even threatened to send asbestos to other units in the building. He also repeatedly played audio recordings loud enough for the entire condo to hear, and harassed contractors as well as members of the board. He argued that the condo had to accommodate him by requiring that the board president stay out of his sight. He sent numerous emails alleging harassment by the president whenever he saw her on the property, and actually took video recordings of her. So the condo sought an order prohibiting Mills from posting unauthorized notices, playing audio recordings in common areas, from threatening directors or communicating with the board except during an emergency, and to allow contractors to access his unit at any time with 24-hour notice being provided or in the event of an emergency. At the time the application was heard, Mills had actually already moved out of his unit, so he had agreed to most of the corporation's requests. The remaining issues to be determined by the court were when and how Mills could communicate with the condo and any third-party contractors. So the court granted the condo's requested order, the only exception being that Mills could communicate with the condo's legal counsel or other personnel through the real estate lawyer acting for him on the sale of his unit, and only for the purpose of completing the sale. So ultimately, the court found that Mills's emails to the condo were oppressive. Email was a suitable method of communication given his disabilities, but the volume of emails, not even considering the tone and content of the emails, overwhelmed the condo's staff, volunteers, and agents, and exceeded any reasonable expectations and amounted to undue hardship. The court also noted in its cost award that neither Mills or his many consultants and lawyers seemed to consider whether he should be responsible for exercising greater control over his responses to stimuli, and seemed to think that his entitlement to accommodation could be used to control others and essentially control the management of the condo. The court also made a point of saying that Mills had 7 or 8 different counsel and continuously sought delays and adjournments, and argued that he be spared the distress of litigating. The court said that in legal proceedings, there are 2 or more parties in a dispute, and each is entitled to vindicate their legal rights. The takeaway in this case is that a right to accommodation to participate in the condo community does not amount to a license to harass, oppress, or unilaterally dictate rules for how the community behaves. This behavior amounts to a dangerous condition under Section 117 of the Act and oppression under Section 135 of the Act. The court stated that the duty to accommodate does not eliminate the other party's rights and the need for owners who require accommodation to obey the law and the rules of the condo. Accommodation is only one side of condo living. While this is an extreme case based on its facts, in these kinds of cases, condos must try to find a reasonable, balanced approach, but nobody is required to endure harassment by others in the condo community. So it's understandable that everyone is frustrated with lockdowns right now, and temperatures can run high, but communication can be oppressive. And again, a balance must be struck between the competing interests and rights of one unit owner and the rest of the community, including staff, agents, and volunteers of the corporation. So I'll go to the next slide, Caroline. So the next case is an Ontario Court of Appeal case, Tscc 1628 versus Tscc 1636. So in this case, the 2 condominiums were party to a cost-sharing agreement, which included an arbitration clause that said any dispute that may arise under the agreement shall be determined by arbitration. There was a dispute about the amounts owing under the agreement, and the parties went to mediation, which failed. The appellant condominium then tried to arbitrate the agreement in accordance with the arbitration clause, but the respondent didn't believe arbitration was appropriate and commenced an application to Superior Court seeking various relief, including an order that the conduct of the other condo was oppressive, unfairly prejudicial, or unfairly disregarded the interests of the condo pursuant to Section 135 of the Act. In response to the application, the appellant condo brought a motion to stay the application in favor of arbitration. The respondent resisted the application on 2 grounds. First, that the application involved parties who were not actually signatories to the cost-sharing agreement, and second, that they were seeking remedies that may not be available through arbitration, including remedies for oppression under Section 135. So Section 135 allows parties to bring an application directly to Superior Court and bypass mediation and arbitration requirements if the conduct of another owner, condo declarant, or mortgagee is or threatens to be oppressive, unfairly prejudicial, or unfairly disregards the interests of the applicant. So the motion judge dismissed the motion to stay and found that the entire matter should proceed before the court because the essence of the claim was oppression, despite finding that some matters were within the jurisdiction of an arbitrator under Section 132 of the Act. The motion judge's decision was then appealed. The Court of Appeal did not agree with the motion judge. In its analysis, the court reviewed a recent decision where the Supreme Court made it clear that a court does not have the discretion to refuse to stay claims that are dealt with in an arbitration agreement. In this case, the court found that the dispute between the condos was clearly covered by the very broad language of the arbitration clause, and the motion judge should have stayed that portion of the application. With respect to the oppression claim, the court did not agree with the motion judge that the pith and substance of the dispute was oppression. The core of the dispute was the interpretation and application of the cost-sharing agreement, and these sorts of disputes required mediation and arbitration under the Act. So the Court of Appeal cautioned courts reviewing these sorts of claims and said that courts should be wary of allowing such claims to overtake and potentially distort the dispute resolution process that lies at the heart of the Condo Act and the preference for arbitration over court proceedings. The Court of Appeal also disagreed with the motion judge that oppression claims can only be determined by a court. The court stated that oppression claims may be determined by arbitrators if the claim relates to a dispute that falls within the terms of the arbitration clause in the cost sharing agreement or Section 132 of the Act. So the language of Section 135 is permissive, not mandatory. In this case, the court held that because of the broad language of the arbitration clause, there's nothing that would prevent an arbitrator acting under the authority of the arbitration clause from considering the alleged oppressive conduct advanced by the respondent. The court allowed the appeal and granted a stay of the application, which means the two condos had to proceed to arbitration. So the takeaways here are that oppression claims can be determined by arbitrators if the claim relates to a dispute that falls within the terms of the arbitration clause or Section 132 of the Act. Not all cost sharing agreements will have such a broad arbitration clause, and in that case, the parties may not be required to proceed to arbitration. So I think now we're going to take some questions.
Thanks very much, Julia. I'm sorry, my voice is cracking. So I see in the Q&A box, we have two questions. From your experience, how difficult is it to get the 50% support required to implement a new bylaw? Ashley, you've done this before. Did you want to answer that?
In terms of standard unit bylaws, owners initially have questions about it, but once they understand at the meeting that it's really in their best interest to have it approved, most owners are on board. However, our office did act, there was a particular case called La Fembois, whereby it basically stands for the proposition that the 50%, it's supposed to be the majority of the owners present at the meeting, not the majority of the owners throughout at the entire unit, at the entire condominium. So it is, it might seem like an uphill battle, but at the end of the day, the vast majority of the condominiums that we work for obtain the requisite consent required.
Yeah, I would have to agree with you. And I think one of the things that really helps in the process is actually having a town hall meeting in advance or an information session so that people can ask their questions, because I think there can be they can feel overwhelmed and they won't always understand what they're giving up or putting a cap on. So what the board and the solicitor and property management can hear is where the concerns lie, even augment the draft and then take it to a vote. So I think it's also how you set it up for success in your condo. But I think, and I agree with Ashley, that once people understand that has a direct impact on the costs of operating, that most communities get on board and you can get that 50% plus one unit for a majority. There's another question, which is how important are appraisals and what is personal risk to directors if they haven't had one since 2005? Okay, Ash, do you want to start with that?
Well, just in conducting research for this webinar, it is recommended that corporations have appraisals. I mean, that is important. In terms of the personal risk to directors, if one hasn't been conducted since 2005, unless the corporation has received written communication from a professional like an engineer or a lawyer stating that the corporation needs to have an appraisal, someone come in to conduct an appraisal. And if the board, does not abide by that recommendation, then the directors would be potentially subject to personal liability. However, as long as they're acting as a reasonable person would in the circumstances, they would not be subject to personal liability. But if one hasn't been conducted since 2001, I think it's a good idea to have.
2005, yeah.
2005,
I think
have someone come out there.
that's the trigger though. I think the date assets and costs for replacement and market values have really changed. I think that under Section 37, being prudent and reasonable is really important. And I think we really need to think about what is the industry practice. I see appraisals every year, every second year, I think it's a common thing to undertake. And it's the only way that you can get an expert valuation on what the assets are worth and make sure that they're insured at adequate levels given, growth and shift and change in assets. So 2005 would be a real sort of warning bell for me. If you said 2019, 2020, I'd be like, okay, that's not going to be far off, but that's a significant amount of time. That's 17 years. Things have changed. So, to me, I think the directors in that particular circumstance risk, a concern about negligence, because to me, that doesn't sound like, if I was sitting on a board where that was happening, I wouldn't be comfortable personally.
Mm-hmm. There's another question about water damage.
Yeah.
There's one question about water damage. The question is, if one unit has water damage due to the negligence of the unit above, does the property manager need to get a quote to restore the damaged unit back to original, or just restore the damage back to the standard unit? So the corporation's insurance or obligations are always going to come in regardless. They're going to step in. In terms of the extent of the corporation's obligation, it depends on whether you have a standard unit bylaw or a schedule. If you don't have either, then arguably you have to return the damaged unit as it was prior to the loss. However, you could take the position taken by the condominium in D'Alessandro that certain items in the unit are upgrades and should not be repaired by the corporation.
Yeah, and I think you talk to your brokers, and you'll also see insurance adjusters, I think, also pushing the position that, it should be restored to the way that the unit was at the time that the declarant turned it over. Sometimes it's hard to find that evidence for sure, but really, one thing about insurance is that it's really co-insurance. It's the corp and the unit owners all together under one policy. So it's really important to appreciate the fact that if there's an insurable loss and the insurance coverage is triggered, then it must be dealt with. And it's about the adjuster knowing that what the standard unit is, and that would be the standard to which we would restore it. Thank you, Babak, for your point as well. Most declarations also provide how often the insurance appraisal should be obtained. So if your deck is very clear and you are not complying with that, then you're in breach of your obligations as a director. So that's extra evidence. So thank you very much for that. So we've come to the end of our hour, and I wanted to thank everybody who participated and joined us today and shared their information with us around, what you're seeing in the insurance premium categories and deductibles. Hopefully we, stabilize, and we all as an industry, and we see some softening of the market now that we've gone through this. And what I wanted to also let you know about our upcoming CCI events, if I could have the next slide. So as you can see, there are quite a few talks that are going on a variety of topics. And some of them have already passed. I'm sorry, we should have updated our list, but you'll see that you can actually participate in, even now golf tournaments are coming back if you're out in London. And Grand River has finance and liens that are coming about. And it as a topic, and Toronto is going to be talking about the CAT and expanded jurisdiction. And I think that's an important topic for everybody to pay attention to. So take care. I'm glad to hear that the numbers are going down. I appreciate you being with us, and we'll let you know what the next CondoWise topic is. Take care. Bye-bye.
Take care, everyone.